Who is that lady?
I think it's Siri. No. Good. It looks like people are starting to log in, so that's good news.
I've learned that with Zoom meetings, people tend to log in right at the time it starts.
Yep.
Within the next 30 seconds after this.
So everyone who's here now, thank you for being our early birds, so to speak.
Okay, people are still coming on, so we'll give them just a minute here. Good afternoon and welcome to this program that is one of the events celebrating the 25th anniversary of the University of Pittsburgh School of Law Center for International Legal Education. Before we begin this program, I want to invite you to some of the next programs. We're doing one a month to highlight the anniversary of CILE. Next month, again on the 16th but of March, we will have with us Marquetta Lent to give the 28th annual McLean Lecture on World Law. Marquetta is a Pitt Law grad who is a partner with Sidley and Austin in Chicago and is now the former past president of the American Immigration Lawyers Association. She will be speaking on cleaning the sand out of the gears, unwinding the Trump administration's extraordinary use of executive action to restrict immigration. In April, on the 8th and 9th, we will have a conference on sovereignty, humanity, and law, co-sponsored by the Law and Humanities Institute. And on May 18 through 20, we will have a conference that we've titled Deals and Disputes, China, Hong Kong, and Commercial Law, co-sponsored by the University of Pittsburgh Asian Studies Center. We invite you to take a look at and register for each of those on our CILE website at law.pitt.edu/CILE. Today, we are pleased to bring you a program on global privacy law in conflict. Our guest today is John Kropf. John is the corporate privacy executive for Northrop Grumman Corporation. Prior to joining Northrop Grumman, he worked as Deputy Chief Counsel for Privacy and Information Governance for Reed Elsevier. And before moving to the private sector, John served for 23 years in the federal government in legal and policy roles, where his last position was Deputy Chief Privacy Officer for the U.S. Department of Homeland Security. His government work also included time at the Department of Justice, the Department of State, and USAID. He is a member of the International Association of Privacy Professionals. Two aspects of John's experience are particularly important today. First, he is author of a guide to U.S. government practice on global information sharing, published by the American Bar Association and now in its third edition. And most important for some of us, he earned his law degree and a master's degree in public and international affairs from the University of Pittsburgh. He was a student in my classes in a year that would, if we told you, would date both of us more than we're willing to admit right now. So, John, welcome back to the University of Pittsburgh. It's good to have you here with us.
Well, Professor Brand, it's great to be here. I can't believe it's been this many years. I was very happy to have your guidance when I was in the law school, especially around international law. I will say privacy was not really a topic back then. So, but I really want to bring us back to international law at some point in our presentation today, because it is truly an intersection that will be interesting, I think, for people to hear about privacy and global international law.
Good. Well, let's start with the basics. When we talk about privacy in the law, what do we mean by privacy, and what is it that your book covers in that regard?
Sure. I think, privacy as a definition, it has evolved over time. And I think, when we talk about privacy in the law today, it's really the ability to control how your data is used, how your information about you is used. It really developed back in the 1890s. I think it was Professor Samuel Warren and then Professor Louis Brandeis, who later became the Supreme Court Justice, wrote an article about the right to privacy, and this was back in 1890. And they really advanced a brand new theory back then in response to a new technology. And that technology was a portable camera. It was able to take pictures of people and have them published in the newspaper. And so they felt that with this new technology, there should be this new right of privacy. And over time, it is evolved. It isn't just photographs. It isn't just your vital information, your name, your social security number, your bank account information, your health information. With the advancement of technology, the scope of what we mean by privacy continues to evolve and expand. We're now seeing privacy to include things like biometrics, things like your IP address, even inferences that you can draw upon where you might live, what zip code you're in. So it is an ever expanding definition with the advancements in technology. and I'll also say, I'll take a global look here too. In the US, we call it privacy, but if you were to go into other areas of the world, if you went to Europe, they would call it data protection. And they may even take a broader view of it. So it is an exciting area, but it's an expanding area.
Well, and I do want to remind those who are listening in that you put your questions in the chat and we will get to those questions as well. So we invite you to be a part of this conversation. But let's move to that point. How has privacy become a global legal issue, and what is the framework of the law there? Certainly, it must be very different than it was in the 1890s when Brandeis began to write about it.
Absolutely, and it has evolved as a global issue through commerce. As we developed this definition up through the 1970s and 80s, there really were not many laws on the books that addressed privacy in the US. We did have the Privacy Act of 1974, which applied to information that was collected about American citizens and residents, but it really was domestically focused. And it wasn't really until, I would say, the mid 1990s when the European Union passed a truly comprehensive privacy framework called the Data Protection Directive of 1995, where it did regulate what type of personal information could be exported across international borders. And that 95 directive in Europe really set up some disputes between what data could come out of Europe and go into the US and for what purposes. And it was soon after the passage of this law that the US government and the EU had to sit down and work out an agreement as to how that data could freely be exported from the EU to the US. The European Union had put a number of restrictions around how the data could leave the EU and how it should be safeguarded. And so the US needed to finally step up and look at how Europe defined privacy and what safeguards it needed. And that agreement that was finally negotiated came to be known as the Safe Harbor Agreement. It was concluded in 2000, and I look at that as really the moment in time where privacy is elevated to this global issue that is now it's affecting business to business flows, business to consumer flows, business to government flows, and government to government flows. There are differences in the frameworks between how the EU views privacy and how the US views privacy. And this first agreement was an attempt to reconcile those differences.
Well, privacy, though, in the United States, we haven't had a clear source of law on privacy. In cases like Roe versus Wade, they referred to the Ninth Amendment and other sources for the right to privacy. But now we see concern both with government and business use of our personal information. The GDPR, the General Data Privacy Regulation in Europe, has caused a great deal of consternation for businesses to try to keep up with that, whether they're in Europe or not. Has Europe taken the lead from the United States on this? Is Europe kind of demonstrating where things are going to go?
I think that's a great question, and I think that the comprehensive privacy law that Europe has put forward in 2016, the General Data Protection Regulation really has set up the dynamic. For the rest of the world to look to. It is, because it's European, it's very prescriptive law. It's very comprehensive in what it expects companies and organizations to do. And you find really, I think that there are sort of three models emerging globally. I think that you have those countries that are following the European framework, that are really trying to track to the GDPR standards. You have the US, which to date has taken more of what we would call a patchwork approach. They have regulated in different sectors around financial services, health law, educational information, so they don't have a comprehensive approach. And then you have the rest of the world who is sort of standing on the sidelines, looking to decide, which model do they want to go with. And I would say that Europe has been leading the way. That is their stated strategy and their purpose. While they have certainly a more comprehensive law, I think there are some that view the US as actually having a better track record around enforcement with the Federal Trade Commission, that they have issued some very strong enforcement actions against companies like Google and Facebook. I think Europe could probably be a little stronger on enforcement, which they are starting to do, and the US is I think primed to look to having a comprehensive federal privacy law. And that's one slice of it.
Well, that answer kind of goes in a direction that begins to answer the question that's come in from one of our viewers, Jason Holm, about the European general approach and the US sector specific approach. CCPA, HIPAA, different areas of regulation. And the US has taken more of a sector specific approach, as you said, patchwork. Which is one approach better than the other, or are they just different ways of addressing the same thing?
Yeah, for me, I'm going to just say that I think at this point in time, generally industry here in the US, at least, private sector is taking the view that a comprehensive federal privacy law is that we are more than ready for it at this point. You have states like California, who has passed the first comprehensive state privacy law. You have 50 other states, all 50 states have passed some law around standards for data breach reporting. And for a company to try to start meeting all of these different requirements at the state level becomes very complex. And I think companies are now thinking, let's have a unified federal privacy law. Microsoft and others have come out in favor of this approach. And in addition to which, I think passing a federal privacy law would likely have some very positive effects for the US globally, in terms of presenting itself as a strong defender of privacy rights. The patchwork approach may have worked at one time, but I think the time is come that a federal comprehensive law is the direction I think we're headed in.
But that raises another question. You talk about state regulation and federal regulation, and then we look at how it all fits in on a global scale. And this comes in a number of places in our intersection with foreign partners. Article 1 gives Congress the power to regulate both interstate commerce and foreign commerce. And I would assume that that's the power under which legislation could come from Congress on this. And you've seen it from the government side, you've seen it from the industry side. And is industry most interested now in, certainly you want as much of it in one place as possible. Is the move when industry discusses this with government officials and representatives, is the discussion to try to federalize in a way that would preempt state law?
Well, I think that you put your finger on probably what is one of the biggest issues regarding a federal privacy law, is would the federal law preempt the state laws? And there's a lot of energy around that part of the debate. Would the federal law, should it set a minimum standard, and could states go above that or not? The other area where there's a lot of debate with the federal law is the right of private action. Can individuals have a right of private action, or would it be enforced by government regulators like the Attorney General for that particular state? I think looking globally, companies and organizations are also promoting the idea of a federal law as saying, this would help us in negotiating these future agreements with our foreign trading partners like the EU. I believe that the EU and the US are probably the most digitally connected trading zones in the world. They account for about the third of the world's GDP. And we have gone through a number of these agreements with the EU. First it was the Safe Harbor, then it was something called Privacy Shield, and they have both been struck down by challenges through the European courts. And to have a federal privacy law would position the US in a much stronger way to maintain these digital flows of information that are so vital to the world economy.
Which brings a further interesting question in terms of global structure, and that is that we assume the United States is the federal system with a central government, but this is an example of where Europe has centralized much more than we have, and taken that from the member states, given it to Brussels, and working from the center rather than out in the parts, and that creates, it obviously creates an ability for them to negotiate with other countries in ways that, if we're going to regulate state by state, that we don't have on a global scale.
Right.
We really do have to federalize and centralize if we're going to negotiate one-on-one with other countries. And do you see this? Do you see any kind of supranational framework ever coming to this, or will it be European rules, U.S. rules, state by state or federal, or is this an area in which treaties would be a good idea?
Well, I think, first off, I think it's an incredibly exciting time to be involved in work in global privacy, simply because there is still yet to be a global standard, a consensus standard. And as I said, you've got this European standard, but it's still working itself out. I think that they bring to bear all sorts of international law issues that are going to be a challenge to work out with the rest of the world. They have a doctrine called adequacy, and essentially the European Union will determine whether a country has an adequate data protection framework that is sufficient to protect the fundamental rights of European citizens. And it's a bit of a white list. If you don't meet the adequacy standards that they set, then data can't flow freely into your country. And I think it really it really brings to bear all of these classic international law issues that you face in other areas. It brings into account, conflict of laws, extraterritoriality, jurisdiction, trade, by having this sort of adequacy approach. And I think that my view is that if there's going to be an international consensus or guidelines or standard, that there's going to be some more reciprocity that has to take place in terms of the ability to recognize other standards, other ways of governance that are effective. The US and the EU are still working through this, and I think there's an opportunity there. I think the US and the EU could agree, that could help really set a consensus or set a standard for the rest of the world to follow. And I feel the longer this goes on, the more of an opportunity that's being lost, because we are essentially both open democratic societies that ought to be able to come to agreement and trust each other on the sharing and the use of data.
Yeah.
So let me just stop there.
Yeah, you mentioned extraterritoriality, and this is one of those areas in which that becomes quite often clear. And I'll give an example of that. Just in sending out emails to announce this event, if we send them overseas and in Europe, we need to be concerned about the GDPR and their data protection rules in Europe, and whether or not we're in compliance with them, even though we're just a small shop in a corner office in the law school at the University of Pittsburgh. And so there's a whole lot of data flows don't respect borders. And so we come to question the way laws are made and applied across borders in many ways here. But let's move back to, we have a good question from one of the viewers, Gurkan Kappa. Let me just read it to you, because I don't think I can condense it in a way that quite gets it. It's good. What do you think about the relationship between different conceptions of fundamental rights in both sides of the Atlantic and the approaches taken to privacy or data protection? Can this different approach to the regulation, patchwork and comprehensive, be attributed to differences in the rights-based litigation in the US and the EU? For instance, the US lacks the proportionality analysis the European courts have been benefiting from for more than 15 years. Thoughts about that?
Yeah, it's a great question. I do think I'm getting a little bit away from the law here, but I think the differences between the US and the EU they are certainly cultural and historical around the issue of privacy. If you think about the history of Europe in the 20th century, and you can understand why they do take such a robust approach and treat it. They really view privacy is considered to be a fundamental human right in Europe, and it is. While I hear people saying that in the U.S. it is really considered culturally more of it would be viewed as a freedom, I think, but not as a fundamental human right. So that creates some cultural differences. I do think that as a matter of, at a principles level, there's not that big a difference in terms of the principles of privacy between the EU and the US. I think where the differences come are really around the implementation. For example, the EU asserts that you have to have an independent entity to do oversight and regulation for privacy, and they view many of the US governmental structures as lacking that independence. So I think the differences start to show up at an implementation level. But I want to go back. There's a great article from many years back now. I think it's the late '90s. It was in the Yale Law Review, about, it really talked about the difference between the EU and the US as being between dignity and freedom. And I think that we can understand those differences, but I still think I'm an optimist. I think we can bridge those gaps through, if we move a little closer together, if the US enacts a federal law, I think that will show, to European minds, we're dedicated, we take it seriously.
There is this distinction between how we think of rights and what we call our Bill of Rights in the Constitution is really a list of limitations on the government. And so we most often think of rights as between the citizen and the government, or the person and the government, and what the government cannot do. And when we think of privacy, we may think, we've always, the tradition has been to worry about governmental intervention, but it's private sector intervention in my private rights that are just as important, or maybe more troublesome now. And Europe, by granting substantive rights to privacy rather than by imposing limitations on the government, really, it seems to me, has a structure that can more easily make that applicable to both relations with the government and relations with other persons, particularly large business entities. Does that make sense?
Yeah, I'm going to make a statement here. This is just my own personal observation from when I was at Homeland Security. I had the opportunity to be involved in a State Department in 3 or 4 negotiations around information sharing with the Europeans, and what they would tell me sometimes is that they saw the difference between the US and the EU around this is European citizens trusted their government more, but they were very skeptical of private sector companies, whereas the US, it was the flip side. It was that people felt they trusted companies more. They were happy to give their date of birth and their family names to the local grocery store so they could have a loyalty card, but they were more skeptical of sharing information with the government. So I think there is sort of this inverse feelings of trust about government versus private sector. The problem with that is, though, the government can access the private sector data for different purposes, for law enforcement or national security, and a lot of the tension comes around, well, how much should the government be allowed to collect that information from a private sector company?
Well, and we as lawyers have a different view of that than European lawyers, I think, too, as well. In the United States, we're accustomed in the litigation process to having a full open discovery and being able to get at all the information the other party has. In Europe, that's much more limited, and secrecy laws apply to private parties, and they can keep the information secret that we wouldn't think would remain secret here. So the starting point really is a bit different. How about your book? How does your book on U.S. government practice fit into the current global privacy debate?
So thanks for asking. I'm going to do one shameless plug here. Here's a copy of the book in case you want to see it. I have it handy. So the book is called A Guide to U.S. Government Practice, and really it came out of practical experience in the negotiations that I mentioned earlier with Homeland Security. We were involved in it was an agreement. This was after 9/11, where there was a lot of need to take greater scrutiny of immigration controls, who was coming into crossing our borders into the U.S., and there was a negotiation that was underway to ensure that European originating flights into the U.S. that is the U.S. government would be able to collect the personal data of the passengers, and to be able to do vetting before the planes arrived, and they would be prepared to vet and know who was entering the borders. And during those negotiations, there was really no source or no consolidated reference material to go to see what other agreements had been out there. So this was inspiration to go out and collect it and put it together in a reference guide, because the number of these agreements that were being negotiated by the US government continued to proliferate. I mean, it was not just in immigration, it was also in trade, it was also in other areas. And so I thought this book would serve as a good reference guide, number one, and number two, that it would demonstrate that there is an existing practice out there regarding how the U.S. entered into these agreements, and that it followed certain principles. It followed what's called the fair information principles, sometimes called the FIPS. And so that was the starting point for the book.
And that was the starting point. Now you're in the third edition. What have been the major changes you've had to make as you do new editions of the book? How has it developed to change from when you first wrote the book?
Yeah, so and in fact, I will mention to you the number of agreements keeps accelerating. So the idea of issuing new editions was that we wanted to add the new agreements that were being negotiated. For example, with the first edition, I mentioned there was the safe harbor agreement. Well, that was invalidated by a European court. So in the next edition, I had to do the new agreement, which was Privacy Shield. And I will tell you, since this book came out, Privacy Shield's been invalidated. So there'll be a fourth edition that will have to show what that new agreement. But it's also shown there are new areas like in the area of trade, for example, with the new agreements that replaced NAFTA. I think USMCA, if I've got the acronym right, between Mexico and Canada, they have a significant chapter on digital trade. Now, those really were not addressed in the earlier editions, and it's just showing that the digital trade continues to expand and continues to accelerate. So my hope is to keep capturing the developments in this area. And I'll say the first agreements around information sharing were very, very short and simple ones. They've now gone on to be extremely detailed and complex. And so I think it's showing how much more advanced the parties are in terms of looking at each other's laws around data protection.
So you are the privacy executive, corporate privacy executive for Northrop Grumman. Is that a part of General Counsel's office? Is it a separate office? Is it a part of compliance? Where does that fit in the kind of traditional structure into which lawyers enter corporate world?
That's a great question. So obviously, lawyer by training, and I have served as a traditional lawyer in most of my career. However, privacy is one of those areas where it's one part law, it's one part policy, it's one part IT. And for that reason, because it's a blend of so many disciplines, the privacy function in organizations can sit in different places. Yes, it often sits in the law department. It might sit in the compliance department. In my particular organization, believe it or not, I sit in information security, and that model works well for us. We're a global company of 90,000 plus employees all over the world, and we're not consumer facing, so I'm focused primarily on protecting the data of our employees. But for another organization like a Google or an Amazon, it might sit in their law department. So no one model, but definitely lawyers and the law have a huge role to play in this area.
Well, you kind of indicated how you've moved from lawyer to privacy, or to specialization in privacy law. I mean, was there at Homeland Security? Obviously, that became important. But was that an evolution, or was there a single? You talk about 9/11 have been important. Was there a single event that made the most difference in that process?
It probably was 9/11. I would say that when I graduated from Pitt, my goal was I really did want to work for the State Department doing international law. And eventually I came down to Washington. I did land a job in the legal advisor's office. But back then, privacy really didn't exist. And it is much of a developed subject matter. And but one of my assignments at the State Department was, the legal advisor's office, was to take on privacy and freedom of information. I thought, I'll do this for a little while, but I really want to get back to that international law that I came here to do. And over time, events changed, and it went from being kind of this sort of management function to a much more important international issue of sharing information. And 9/11 was a big event for many reasons. The aftermath of needing to protect our borders required that we shared information with friends and allies. And so that opened up an opportunity which took privacy into the international space, into the international law space. And ironically, I probably did more international law when I moved over to Homeland Security to build out an international privacy program and negotiate these agreements than I did at the State Department. But I didn't pick privacy. It picked me at a certain point.
Yeah, well, that's interesting. And you've talked about the kind of legal framework for privacy law. Now, can you highlight what you think are some of the current issues or developing issues that are going to come along that demonstrate either the application of those laws or the need for changes in those laws?
Sure. Again, as I mentioned at the outset, I think privacy is incredibly exciting because it does change so quickly. There are so many new issues coming along with, as technology gets more sophisticated, so do the uses of data. And with that, so do the need to use that data in a proper way. And in areas like artificial intelligence and machine learning, this is a huge area where personal data is being collected and used and processed in ways that we couldn't have imagined 5 or 6 years ago. And so as AI advances, you're going to need people with the right skills to look at how to use that data. And there are a lot of companies, again, the big ones, Microsoft, IBM, Google, are issuing statements about how data should be used in artificial intelligence. And they're ethical statements because a lot of the law in this area is not keeping up. So lawyers for these organizations are building out frameworks. And so that's artificial intelligence, and machine learning is another area. is the first area. Internet of Things is a huge area where you've got virtually everything from your shoe to your coffee maker equipped with chips that collect potential, personal information and send it out to the internet to be processed. And how does privacy work there? How are you protecting those interests? And again, huge opportunities for subject matter experts in privacy. So those are the technological areas. I think in the international space, which happens to be my personal kind of passion, is right now they're still working on trying to find common standards and agreed upon standards that will allow for free flows of data for commercial purposes, and negotiating a new agreement with Europe is already been stated as a priority for this new administration to replace the agreement that was struck down, the Privacy Shield agreement. So there's huge opportunities in many areas.
There's been a lot made of how different people think of privacy differently, and in particular discussions about generational differences and younger generations seeming to assume that their lives are a public matter on whatever social media platform is the platform of the day. We saw on January 6th how a lot of people shared with the world things that as they then exited the Capitol building and later found out that they may not have wanted to share in that way can be used. Do you see in your work either in the business setting or with government these generational differences having any impact, or is it a generational difference? What is the difference between people's expectations? Where do the differences lie, and how does that affect the development both of business policy internally and efforts to change the law?
Sure, it's absolutely a right-on question. It faces me every day. I remember reading a book some years ago, and I may get the title wrong, but it said it distinguished the world between two groups of people: digital natives and digital immigrants. And I think that the cutoff was if you were born before 1980, you're a digital immigrant. If you're born after 1980, you're a digital native. And there's something to that in terms of how you approach and feel about technology in your life. And I'll tell you now with millennials and folks a lot younger than me, when they're in the workforce, they really want to have access to their work devices when they want, where they want, wherever they want, and so that is presenting new challenges. If you're carrying a phone around, there's a lot of sensitive data on that, and at the same time, you have to be sensitive to where the workforce is going, and presenting them with options that are appealing to them. Because if you don't, you might lose them to the high-tech company that does allow for remote working or bringing their own devices.
Yeah. Well, let's talk about I guess that group that's coming into the workforce, law students, recent law graduates. To those who are tuned in right now, listening in, what's your advice to them in terms of this as a field for practice of law? Would you advise they go into it? Is it a good one for them? And if so, how should they prepare for that?
Yeah, I'm particularly biased. I would absolutely encourage any law student or someone that's early in their legal career to take a look at privacy, data protection, cybersecurity as a potential subject matter area, it is only continuing to grow in demand. I mean, around the issues that I mentioned earlier. But let me give you an example. When I first started in privacy formally with Homeland Security, I joined an organization that called the IAPP, the International Association of Privacy Professionals. They were still under 1,000 members. It is now over 60,000 members, and this is over a period of maybe 20 years. And it is continuing to grow and make it leaps and bounds. And most of that growth is really international, because of all of these laws around the world are really looking for companies to establish data protection officers or data protection leads. And that's creating a huge demand. So not only do you have that demand, but you have all sorts of specialties. You could be focused on an international side of it. You could be focused on health information or AI. It's only going to grow in demand, and I see it in terms of trying to when I recruit, needing to see that there are qualified people out there that are dedicated to it. So I strongly encourage it.
And what kinds of, remembering that law school courses come along after legal practices develop, what kind of courses would best prepare someone for that practice?
Well, I always remember, though, you gave a great piece of advice many years ago, which is if you want to go specialize in something, first you really need to build a strong foundation in the basic courses. So doing that is important. But if you really want to go and specialize, I mean, I think having an understanding of IT, and I'm sure by now there must be some courses that touch on privacy or information law. So learning that as a specialty. In the international area, if there's something I wish I knew a little bit more about, is probably comparative law. Understanding, really understanding what is a civil law system versus our system based on common law. And if you wanted to specialize, I think, if you understood health law, that would probably give you some insights around HIPAA and the health privacy area.
We have another good question from the audience, and I would, for those of you in the audience, if you want to get that question in, put it in now. But has the U.S. approach to privacy changed under the current COVID-19 situation? For example, some countries impose contract tracing apps to be able to monitor the movement of their nationals. How has the pandemic affected privacy?
Yeah, I mean, I haven't particularly seen, from a legal standpoint, that there's a significant federal change, but just from an organizational standpoint, I know organizations say that have, say you have a large manufacturing environment. I mean, you really need to find a way to bring in technology. Say, if you have a wearable device that tracks employees on your manufacturing floor, well, privacy has a role to play in that. What type of information are you tracking on these wearable devices, and geolocation? How much information should you collect about their whereabouts, and how long do you keep it, and who gets to see it? In addition, you've got contact tracing now. If your workforce is going to be reporting whether or not they might be infected, well, okay, then you need to put some guardrails around how is that information collected and shared, and again, how long you keep it. So I like to say that almost every issue at this point has privacy attached to it in some way. And certainly COVID, you're dealing with what, from a risk standpoint, what's considered to be sensitive personal information, and there's definitely a piece for privacy to play.
The privacy officers, though, that one of those things that students are thinking about, that the practice would be developing the policies that help protect both the business interest as well as the privacy interest of the employees within the organization. Is that a fair statement?
Yeah, it is. And again, I keep commenting on it from a sort of an HR standpoint for an organization, but I can only imagine if you're one of these companies that's marketing the devices, you have to have somebody there that can build in privacy by design when you create the product. So it isn't unnecessarily collecting information in an unsecure way. So from that standpoint, privacy is not just it's not just a cost center. It's really it's a business opportunity, I think, for companies that are collecting and using data. You need to show that you understand privacy. And just to sort of highlight a dispute right now that's going on is between Apple and Facebook. Apple has always marketed itself as, privacy is part of its brand, and they see that as a business opportunity. So it isn't just a compliance function.
Yeah. Well, John, I think this has been a wonderful walk through privacy and the global aspects of privacy. Really appreciate you taking the time to join us for this, to come back to Pittsburgh. I wish you were here so that we could go out and have a nice lunch afterwards and continue the discussion and have some students sit with us for that. But it's been a wonderful opportunity. I hope that we'll be able to get you back here once things open up post-pandemic, and we can share time together in the same space. For those who are out there who have joined us, thank you for joining us. And this, remind everybody, this is a part of the celebration of the 25th anniversary of the Center for International Legal Education. We hope you'll join us for the events we're going to have in March, April, and May. Again, you can find them at law.pitt.edu/CILE. So take a look, come back and join us. And again, John, thank you so much. Really appreciate you being here with us.
Well, thank you, and thank everybody for joining in. I hope this was useful to folks, and there's questions that you wanted to pass on that you didn't get to. I'm happy to answer them offline.
Okay.
Thank you.
Goodbye to all.